Welcome back, everybody. This is Michael Levitis from JurisQ.com with Steven Yuniver from Sinayskaya Yuniver, a law firm that handles many different practice areas. Right now, we're going to focus on commercial real estate. Steven, welcome back.
Hi, thank you, Michael. Thanks for having me back.
Thank you. We're going to talk about something that's very, I would say, realistic and practical right now for people who are entering into commercial leases, or even landlords who are leasing out their commercial spaces post-COVID. COVID came in fast, came in as a surprise, and the case law was tested, right? The contracts were tested, and you have seen as a result that now you have to adjust some clauses, put in new clauses in your lease agreements. Can you talk about that? What changed post-COVID?
So I think that's a very your comment about case law and clauses being tested. It was the first time that there was clauses in law from the 1920s, even the 1800s, that were being decided once again in the Court of Appeals in New York. It was insane. Frustration of purpose, legal words that never left my mouth before. All of a sudden, it's all on all my papers. It's visible. Everybody knows the landscape has changed. Depending which borough you're in, Manhattan had a sharp decline in commercial real estate. Brooklyn, commercial real estate and commercial leasing just shot up. People did not want to stay at home. They wanted to go to work. They wanted to be in an office. For some reason, not in Manhattan. So the pricing has changed. Everything has changed. What we've noticed is force majeure clauses were tested every single day. What does force majeure means? Something happens. Act of God, storm. Last time there's only in the last 20 years it's been tested 3 times. First was September 11th. The second was Hurricane Sandy, and this was the 3rd time it was tested in 20 years. And for some reason, this is the first time that people really started taking it seriously, because nobody was getting evicted for 3 years almost. So it's very important to understand these clauses to make sure that everything's included.
What does it say, a force majeure clause?
So there's the general force majeure clause, the act of God clauses, that strikes, acts of God, and dangerous things will not release you from liability, but will potentially release you from the lease. So and it's confusing language. What I think I told you before, it's very important not to have vague clauses in leases. And these clauses, nobody used them, so they just threw in this generic wording and finally being used, and now it's being litigated. What did you actually mean?
Exactly.
So now the clauses went from being 1 paragraph to 3 pages. And now you have to understand what you should put in there. If you're a healthcare professional, you're going to put in there that disease is going to be a force majeure clause. If somebody comes in with smallpox, does that mean I don't have to pay the lease because I'm closed down for 2 weeks? Or if you're a construction site, I know I can't build right now. What should I do? Can I get out of the lease? So these clauses are extremely important and to be extremely written specifically on the landlord and the tenant side. Because if it's so vague, then you're just relying on this one person, this one judge that's going to hear you and say, what does this actually mean?
Yeah, like you said, Steven, before, I guess people were just throwing in those clauses because it was just part of the form. People didn't give it much thought. And now the message I'm getting from you is that the clauses have to be tenant specific. So depending on what your business, it depends on what you want it to say in case there is a medical emergency or some kind of a terror attack or a natural disaster emergency. What do you want the case to be? What happens with your lease when this occurs, correct?
Correct. It's very important because not only are judges looking at this and tenants and landlords, but also insurance companies. They want to make sure that if all of a sudden you're shut down or something bad happens, your lease was written correctly. And trust me, insurance companies want to save money. So if there's something there that's off, they're going to say, well, you didn't put the right thing in there. We're not going to give you coverage.
Oh, so when you draft that clause, you have to think about your business, but you also have to think about potentially an insurance claim.
Well, that's what the attorneys are for, because you should focus on your business, making sure that you're being protected. But yes, that's exactly it. God forbid something happens. Another pandemic. Let's hope not, but if it happens, or what's going on in Florida now with the hurricane. You never know what could potentially shut down your business for a long period of time, and yet you're still liable for the rent that you have to pay.
Wow.
And commercial rent in New York isn't cheap at $55 a square foot in some places.
Mhm.
So these clauses are very, very specific to make sure that you're protected for any kind of potential outcome.
So Stephen, thank you for this broad overview. Let's just talk about some points of force majeure clause. You mentioned one. What happens with the lease payments? Let's say there is an epidemic, God forbid again, for a year. For that 1 year, do you have to pay the rent or not? That's to be negotiating. What else? How about, let's say, damage from a hurricane? Your whole leasehold, your whole space is damaged. Who pays for the repairs? How does that work, right?
So all that's accurate. So if you're speaking with the landlord, and I tell the tenants the same thing, always get business interruption insurance, and
Mhm.
the landlord should always insist in the
Okay.
leases to make sure it says business interruption insurance. So
Mhm.
that way you're covered. In the force majeure clause, it has to be in there that if there's some kind of stoppage, what exactly is going to stop? Will your rent payments stop? Will your insurance payments stop? Will tax payments stop? Will
Mhm.
water payments stop?
Interesting.
Because technically, if you don't put that in there and you default on one payment, you could default on the entire lease, even though you've been paying 90% of everything else.
Mhm. Mhm.
So
Okay.
that's why these things have to be very specific.
Understood.
Most people don't think about this, and
Of
why
course.
should you?
Yeah, and you know what? You're very right that people don't think about it because people don't like to think about unpleasant things. You want to talk about you building your business and launching it. You don't want to think about, oh, what's going to happen in case of a disaster. But guess what? You as an attorney can testify to the fact that you have to pre-envision worst case scenario. That is your job. And that's why we do this. We educate the public on what's potentially out there. But now the public has to utilize an attorney to get specifics on their case, on their business. That's why we urge everybody to, before you sign a lease, which is a major investment, go to an attorney that actually does this day in, day out, and actually litigates these cases. And attorneys such as Stephen Yuniver. We're going to have the phone number on the bottom of the screen. If you have any questions for consultation, for second opinion, to review lease, and so on, you're welcome to call the number on the bottom of the screen. Stephen, thank you so much for your time. I'm going to come back to you shortly with another question because, as you know, we are here to educate the public. And we're going to talk about personal guarantees and good guy guarantees, what they are as a tenant, what exactly are you liable for when you sign the lease, and then things go south. Everybody, thank you for your time. Stephen, again, it was a pleasure to see you. We'll see you very soon.
Pleasure seeing you again, Michael. Thank you.
Thank you.